My Lords, we were considering the judge's conclusion recorded at paragraph 285 of his judgment, which is at page 195 of the core bundle, that Mr. Ruhan did commit separate breaches of fiduciary duty when acquiring the Hyde Park hotels and applying the profits for his own purposes, and that there are separate causes of action against Mr. Stevens for dishonest assistance. Lord, the judge then proceeded to give three reasons for his having reached that conclusion. And they're at paragraphs 286 to 288 of his judgment at page 196. And I'd like to consider those for a while, please. His first reason at paragraph 286 is, he says, first, the beneficiary's ability to trace into profits made by the trustee through unauthorised dealings with trust assets is often rationalised on the basis that the beneficiary has a right of election between treating such unauthorised act as a wrong causing loss for which equitable compensation can be claimed, or adopting the act and treating the proceeds as trust property. See, for example, Lord Millet in Foskett, citing Professor Williston. It can be argued that if the beneficiary takes this course, then there can be no dishonest assistance in respect of the acts of the fiduciary which are so adopted, leaving only such breaches as the beneficiary does not choose to adopt, which can be the subject of a claim in dishonest assistance. Well, your Lordships will already be aware from my submissions earlier this morning that I say that's wrong. I say in that situation, the beneficiary or the company would certainly be entitled to bring a dishonest assistance claim against the assistant and a novoship type claim for an account of profits. It would be difficult for him to bring a claim for compensation in circumstances where the beneficiary has elected not to claim compensation against the fiduciary. But that's another point, which I'm not going to address your Lordships on, and I'm not in a position to do so. But in principle, the learned judge's invocation of the concept of adoption doesn't, in my submission, doesn't get him where he wants to go. And I infer, it's maybe unfair to the judge, but I infer that where he wants to go is, this is a reason why it is appropriate to start the clock halfway through the wrongdoing. What the judge may be suggesting there is, it may seem odd that you ignore the initial wrongdoing and only look at the loss caused by the subsequent wrongdoing. But the reason for that is because the initial wrongdoing has been cleared off, it's been ratified. And, my Lord, that is not how what the judge refers to as adoption, what is commonly referred to as adoption, that's not how that works. What he's describing is the process of election between inconsistent remedies. This is not a process of ratification of wrongs, it's a process of election between remedies. And one can see that from the very authority that he relies on, which is the well-known speech of Lord Millet in Foskett. And perhaps we could look at that. It's in the bundle it's bundle 3, behind tab 24. The case starts at page 1055. Bundle 3, tab 24. Your Lordships...
Sorry, I've got the wrong bundle. You did say tab 25, didn't you?
Tab 24. 24.
24.
Lord.
I have got
Sorry, the wrong one.
Yeah.
Your Lordships will, I'm sure, recall it was a case of mixed substitution into some insurance premiums, which paid on the insured's death, and he conveniently, for the claimants, died during the course of their claim. But Lord, if I could pick the most famous part of his judgment, it's at page 1083. This is all under the heading, the tracing rules, in the previous page. And Lord Millett says, the simplest case is where a trustee wrongfully misappropriates trust property and uses it exclusively to acquire other property for his own benefit. In such a case, the beneficiary is entitled at his option either to assert his beneficial ownership in the proceeds or to bring a personal claim against the trustee for breach of trust and enforce an equitable lien or charge on the proceeds to secure restoration of the trust fund. This may in part address the question that your lordship, my Lord Justice Newey asked me this morning. And that's about, I'll carry on. He will normally exercise the option in the way most advantageous to himself. If the traceable proceeds have increased in value and are worth more than the original asset, he will assert his beneficial ownership and obtain the profit for himself. There is nothing unfair in this. The trustee cannot be permitted to keep any profit resulting from his misappropriation for himself, and his donees cannot obtain a better title than the donor. If the traceable proceeds are worth less than the original asset, it does not usually matter how the beneficiary exercises his option. He will take the whole of the proceeds on either basis. That is why it's not possible to identify the basis on which the claim succeeded in some of the cases. And then he says, both remedies are proprietary and depend on successfully tracing the trust property into its proceeds. A beneficiary's claim against a trustee for breach of trust is a personal claim. It doesn't entitle him to priority over the trustee's general creditors unless he can trace the trust property into its product and established a proprietary interest in the proceeds. And this, of course, brings up an earlier discussion that we had this morning. If the beneficiary is unable to trace the trust property into its proceeds, he still has a personal claim against the trustee, but his claim will be unsecured. Now, Lord, your Lordship will see that just by letter C, at the beginning of that paragraph, he refers to those two alternative options as remedies. What he's describing there is a process by which the victim of wrongdoing has an election between two inconsistent remedies. He can choose one or the other, but he can't choose both. He can choose a personal claim for compensation, and if the money that has been taken has been used to acquire an asset, he can claim an equitable charge over the asset to secure that personal claim, or he can choose the property that has been acquired. If he chooses the property that has been acquired, he takes his chances. The property can go up in value, it can go down in value. It's not that the trustee in that situation isn't under an obligation actively to manage it for the benefit of the claimant, obviously. So where Mr. Justice Foxton talks about adoption, that is how one often, one sees that word often in the reports. It's a word I'm sure I've used in this context often myself. But it isn't adoption in the sense of ratification. It's not adoption in the sense of approving the breach, such that it ceases to be a breach of duty which is cognizable by the law. And of course that must be the case. To take a case not of tracing property, but take a case of claiming an account of profits in the alternative to a claim for compensation. It could be said that you've adopted the wrongdoing by claiming an account of profits, but it has to be wrongdoing. There has to be a breach of fiduciary duty for you to be able to claim an account of profits. So, in my respectful submission, the learned judge was wrong to think, as he appears to have thought in paragraph 286 of his judgment, that the election would prevent a claim for dishonest assistance. There having been an adoption, loosely so called, this would prevent any claim being made against a dishonest assister. It wouldn't therefore somehow authorize a claim, in relation to the next starting the clock halfway through the wrongdoing.
Can I just read it again to understand?
Yes.
Yes, I see.
Furthermore, and in any event, whatever is the juridical consequence of adoption, in my submission, it doesn't mean that the adopted breach should somehow be ignored in determining whether the beneficiary has suffered a loss in respect of which equitable compensation should be awarded. In my submission, it doesn't affect the process, the intellectual process that the courts must go through in determining whether, in determining the counterfactual by reference to which the loss should be assessed. In my submission, where breaches are inextricably connected and are effectively part of a single scheme of wrongdoing, the earlier breach can and should be brought into account in determining loss, so as to allow the court to make a fair, just, and reasonable assessment of loss on a common sense basis. Lord, stopping there, my Lord Justice Mayles raised the interesting question of equitable set-off this morning. I confess it isn't something that on this side of the court, it's not an analogy that on this side of the court it had occurred to us to draw. But there is if I may respectfully say so, a very fair analogy. In the case of equitable set-off, the question is not whether two breaches by the same party should be taken in the round. It's whether a breach by one party and a breach by the other party should be taken in the round. The common law is very obtuse about that, or used to be very obtuse about that. It requires complete mutuality to allow that to happen. But equity was always more flexible. As I understand it, the leading authority of equitable set-off these days is a case which I'll be handing up probably this evening. But it establishes that the test for equitable set-off involves both considerations of the closeness of the connection between the claim and the cross-claim and of the justice of the case. There was a formal element to the test, which is closeness, and there was a function element, that is justice. The importance of the formal element was to ensure that the doctrine of equitable set-off was based on principle and not discretion. The importance of the functional element was to remind litigants and the courts that the ultimate rationality of the regime was equity. Lord, not the same doctrine, and I'm not suggesting that the same test would be applied. One can see that there are all sorts of reasons why, if there were to be a general test, one might light upon a different test. But there, if I can use another word used in the authorities, it is isomorphic. There is a clear analogy to be drawn between those two situations, and in my submission, I'll hand up the case at the end of the day. It's called Geldof Metal Constructi against Simon Carves. It's a decision of the Court of Appeal, this court, in 2010. It is, in my very respectful submission, an illuminating analogy to draw, if I may respectfully say so. Lord, that's paragraph 286. Paragraph 287 of the judgment, the learned judge says this: second, the fiduciary does appear to commit a separate breach of duty when it applies the proceeds of trust property, in this case the profits of the sale, for its own purposes. And if there is a separate and significant act of dishonest assistance by the original assistant at that stage, there should be a separate cause of action against the assistant at that point. The issue can be tested by considering the position of a fresh assistant who arrives after the fiduciary has realised a profit from trust property acquired in breach of the self-dealing rule. It seems clear that someone who dishonestly assists the fiduciary in moving or dissipating the profits held by the fiduciary on constructive trust is liable for that dishonest assistance. See above, and see also Lord Minnett's comment in Twin Sectra, that liability for dishonest assistance extends to everyone who consciously assists in the continuing diversion of the money. Most of the cases have been concerned, not with the assisting in the original breach, but in covering it up afterwards by helping to launder the money. If the actions of the new assistant give rise to a cause of action at that point, I have struggled to see why a further act of assistance by the original dishonest assistant has a different status. So, juridically, the use of the profits in breach of a constructive trust may constitute a breach of duty giving rise to a separate cause of action, as I've indicated. and acts of dishonest assistance in relation to that breach can also be said to give rise to a separate cause of action against the dishonest assistant. But that does not mean that the original breach causing the making of the profit should not be brought into account. Given the connection between the breaches, loss, in my submission, should be assessed by reference to the position that the trust would have been in had the trustee not breached its duties at all.
Okay. Can we just pause there a moment and think that through? You say in that situation the loss should be assessed by reference to the position going back to the start. But you're accepting that there can be dishonest assistance in relation to merely what you'd see as a second breach, a breach of the custodial duty in relation to the profits. Have I understood you correctly?
Lord, yes.
And just to be clear, that doesn't obviously follow from Lord Millet. I mean, he might just have been thinking, well, that's assistance in the totality of the breach.
I'm going to come to that. That's in my submission, that's precisely what he is thinking about.
But if he is thinking that, then potentially you have to distinguish between assistance at whatever point it is given in relation to the breach, and on the other hand, the situation which you're accepting, which is that there can be dishonest assistance in relation merely to the second stage in isolation from the first stage.
Lord, before I grapple with your question, may I just make one observation? And in saying this, I'm anticipating an argument I'll be running on my second ground of appeal. But it's this: on authority, any act of assistance given to the original breach, creating a profit, which results in the creation of a profit. In other words, any assistance in the making of an unauthorized profit will also count as assistance in its disposals for it, allowing its ultimate enjoyment. Even if the dishonest assistant does nothing more, nothing positively to help the enjoyment, he just helped the making of the profit. I will make that proposition good later. So it's important to bear in mind that when deciding whether assistance, whether there has been assistance for a breach, the courts do not apply a particularly strong causation test.
I follow that. I just want to be clear, which I think you're accepting, that you can look at it in the two distinct or separate stages. I mean, I quite follow that if you have a situation where somebody gives assistance in relation to an original breach of duty, where there is a follow-through into some profits and the profits are then disposed of, you're taken to have assisted in relation to all of it. Potentially, you might think the same actually applies where you come in later. Lord Millet says, well, often the assistance is covering up. So if you're not there at the start, but somebody commits a breach of duty, creating profits, and then you help to dispose of them at that stage. On one view, you might say, well, you're just assisting in the totality of the breach. You're not assisting in a second stage breach. You're assisting in the totality.
Lord, yes, that is, in my submission, that is the law. If the approach that we're advocating applies as much to an assistant who assists only in the dissipation of the profits as it does to the assistant who assists in the making.
I see that, but you're, as I understand it, accepting that it makes sense to talk of assistance in a second stage breach, so to speak, a breach of a custodial duty, rather than just saying, well, that's an aspect of assistance given in relation to the totality of the making of the profit and disposing of it.
Well, Lord, I'm saying both, actually. I'm not really helping you by answering the question in that way. Could I perhaps take it in stages?
Yes,
I've already submitted that someone who just assists at the back end, as it were, who assists in the disposal, someone who assists at the front end, who assists in the making, is ipso facto liable for the disposal as well, assisting in the disposal as well. I will come to it. The net effect of that proposition on the judge's analysis, it's important to be clear, is that it means that any dishonest assistant who assists, say, a fiduciary in making an unauthorised profit is ipso facto automatically liable for the profit that he thereby assists in the making of, assuming the profit goes. It's a very remarkable result, and it's absolutely contrary to the decision of this court in Novelship. But that's the first point. It makes it, in my submission, it just demonstrates how important it is not to try and salami slice the wrongdoing in a way that produces very counterintuitive answers. Coming to the later assistants, an assistant who is recruited in order to help conceal the profits, that person will be just as much an assistant for the original breach as the person who's recruited just to help in the making of the profit. There's no analytical difference. I mean, my lord, the learned judge refers to the quotation from Twin Sectra. I could equally show you a quotation from Ultraframe. Perhaps we'll have a look at that. It's in bundle 5.
Just before we go there, another way of testing the judge's fresh assistant example may be to consider the position of the fiduciary, who is equally liable to a claim for equitable compensation. Well, if you're right so far in the submissions you've made, a claim for equitable compensation against the fiduciary in respect of the later breach would have to take account of the benefit obtained as a result of the earlier breach. And one would then say, well, it would be odd if the fresh assistant coming in only at stage 2 was liable for the whole lot when the fiduciary himself wouldn't be.
I'm so sorry that my submissions this morning were devoted to the liability of the fiduciary. I say that because of the closeness of connection of the breaches committed by the fiduciary is not liable, or rather, in assessing the fiduciary's liability, one has to take into account the fact that the fiduciary created the profits, such that there's zero loss. I'm so sorry. Perhaps that was an answer to my Lord Justice Newey's question. I say that there's no loss in respect of which the subsequent dishonest assistant can be liable.
That's become a triangular dialogue. I'm not sure that
I'll keep out of it.
No.
It's very helpful.
I think it might be helpful my Lord pursued his point first.
Well, it's simply that assuming that you're right in what you said about the position of the fiduciary, the judge's fresh assistant is liable for the entirety of the profits which have been first earned and then dissipated by the fiduciary, and that seems an odd result if the fiduciary himself would not be liable to pay equitable compensation at all for breach of the second stage, because the claim in respect to the second stage would have to take account of the profits earned at the first stage, resulting in no loss.
Yes. That's my submission.
Positive. So if you're right about that, that's what we'll have to decide, but if you are, then the fresh assistant example is not as powerful as it appears at first sight.
There is a difficulty in relation to a fresh assistant who's around and about at the time of the original wrongdoing. That analysis works perfectly. I don't know why I'm raising this as a difficulty for myself, but it's only right that I should do so. Imagine a case where a fresh assistant comes in 10 years later. The claimant has HB2 has long since gone, has no suspicion of a claim. In fact, what's happened is that the creditors are circling around the head of Mr. Ruhan. And he's worried that the creditors are going to get his £100 million worth of profit. And in that situation, he goes to Cayman or somewhere far-flung, and obtains a money launderer to help him conceal his £100 million from his creditors. Now, that would be a really fresh assistant. And the question then arises, would that fresh assistant be immune from liability? There are two possible answers. One answer might be, consistently with the answer I've already given to your lordships, that because the fiduciary, the dishonest assistant's liability depends upon it's accessory to the liability of the fiduciary, and if the fiduciary in that situation would have no liability, then neither should the assistant. Another possible answer would be that in that scenario where the circumstances are completely different and the purpose of the concealment has nothing to do with the original wrongdoing, maybe at that point the fresh assistant takes his fiduciary as he finds him. And maybe in that scenario it would be possible, at least for the creditors, to sue the fresh assistant for dishonestly assisting in the misappropriation of the trust fund. That's, if I may say so, a difficult, in my case, it's a difficult question. But it's not a question that needs to be answered today. And it's a question which, in my submission, would be answered by reference to equitable principles based on fairness, justice, and reason.
Just getting off the tangent again briefly, of course, it's the more complicated because you don't know until later, necessarily, what election the principal is going to make.
Absolutely.
I mean, if the principal elects to have compensation instead, then it turns out retrospectively that the property isn't held on trust at all.
My Lord, yes. I would very much like to say that those are factors which allow me to say that the constructive trust shouldn't be regarded as a real trust, and that a breach of that constructive trust shouldn't be regarded as a real breach, which would give rise to a pleadable cause of action. I can't, in all honesty, I can't.
You recognise that authorities say there's an institutional trust.
Yes, it's a real trust. So accepting that I'm bound by authority, and this court is bound by authority to accept that proposition, one then considers, well, okay, there's a real trust, but is there real loss? And that's what my submissions are focusing on. This morning, as my Lord Justice Mayles correctly pointed out, I was focusing on the fiduciary's liability, and only the dishonest assistance liability only arises if you establish that the fiduciary is liable for real loss. If the fiduciary isn't liable, then I ask forensically, why should the dishonest assistant? And that works for an assistant. If the fiduciary so organises his affairs that he's got one team member who's there helping him make the profit, and he's got another team member ready to take the profit and whisk it away to Liechtenstein. And that just happens, how he happens to have organised his affairs. It's random that it's, Mr. X is doing the Liechtenstein job and Mr. Y is doing the receipt, the impersonation job. In that situation, it is all one course of wrongdoing, and it would be absolutely wrong for either the fiduciary or the dishonest assistant to be liable because of that separation. Where there's assistance 10 years later, it's a more difficult case. It's not this case. It's nothing. This is a one-scheme case, as I keep repeating ad nauseam. But where there is a truly separate scheme that has nothing to do with the original scheme, where the concealment isn't even concealment from HB2, it's concealment from someone else, I feel bound. I feel bound to accept that there's a question as to whether the same analysis should apply, or whether, because there is now no connection, perhaps a different approach ought to be applied at that stage. that we're outside the Bartlett scenario, because there isn't no longer the connection between the subsequent breach and the original breach, because the subsequent breach isn't done by reference to the original breach. It's not designed to protect the defendant from the original claimant, but it's for some completely different purpose.
Yeah.
So that's paragraph 287 and the fresh assistant. Would your lordships just give me a moment? Perhaps I should, I was going to take you to Ultraframe. Let me do that very briefly. It's in bundle 5. I feel that any case on concepts in equity would be deficient if Ultraframe wasn't, the judgment of Justice Lewison wasn't referred to at least once. And if I could ask your lordships to go to page 1797. Paragraph under the heading 40, dishonest assistance. Mr. Justice Lewison starts by citing the very famous statement from Lord Nichols in Tan, Royal Brunei in Tan. Then in 1496, he refers to Lord Millet's judgment in Twin Sectra. The accessory's liability for having assisted in a breach of trust is quite different. It's fault-based, not receipt-based. The defendant is not charged with having received trust monies for his own benefit, but with having acted as an accessory to a breach of trust. The action is not restitutionary. The claimant seeks compensation for wrongdoing. The cause of action is concerned with attributing liability for misdirected funds. Liability is not restricted to the person whose breach of trust or fiduciary duty caused their original diversion. His liability is strict, nor is it limited to those who assist him in the original breach. It extends to everyone who consciously assists in the continuing diversion of the money. Most of the cases have been concerned, not with assisting in the original breach, but in covering it up afterwards by helping him launder the money. Lord, stopping there, the word continuing diversion is, in my submission, significant. What it suggests is that what Lord Millet had in mind was the single scheme case. The fiduciary plays his trick on his principal or breaches his fiduciary duty to his company. He misappropriates the money, and he's got arrangements in place, or he makes arrangements while doing it, which whisks the money away to some inaccessible jurisdiction. That's what he had in mind. And what Lord Millet was saying was, you can be an assistant who actually whose acts of assistance happened quite a long time after the original breach. That doesn't stop you being a dishonest assister of the original breach. What this isn't authority for is the proposition that there are two breaches. A dishonest assister is, you can have dishonest assistance of the first breach, and then there's a breach of a constructive trust, and you can have a dishonest assister for that. And then there's a breach of another constructive trust when it moves from jurisdiction to jurisdiction, and you can have another dishonest assistant who's breaching that duty. That was not the model that Lord Millet had in mind at all in my submission. Far from it. What Lord Millet was thinking, and in my submission he was correct to do so, he was focusing back on the original breach. And that, if I may say so, underlines the approach I'm seeking to adopt in this appeal. Namely, you can't look at subsequent acts of assistance in isolation as if they had nothing to do with the original breach. That's absolutely not what Lord Millet was saying.
I would be interested to know in due course from either side whether there is any example, A, of an assister being held liable exclusively in relation to a constructive trust stage 2 breach, or indeed of a fiduciary being held liable simply for breach of the constructive trust.
Lord, on this side of the court, we've looked very hard and we haven't found a single one.
Including, as to the second point, whether there's any example of a fiduciary being held liable for breach of the constructive trust.
Perhaps I should correct myself. We've looked very hard for the dishonest assistant question. As to the latter question, we're not aware of an example, but I can't say that we've specifically, for a long period of time, in the way that we have with dishonest assistants, we've done a considerable amount of research.
Actually extending that, what learning is there as to what duties the constructive trustee owes in relation to the profits which are held on constructive trust?
Lord, we've been discussing this over the shorter German, as your Lordship might have anticipated. We'd like to continue our discussions, but our initial answer to that question is that just as where a claimant elects for an account of profits, he takes his defendant as he finds him. So if the defendant makes fantastic profits, that's wonderful. But if the defendant mishandles his investments and he only makes limited profits when in fact he should have made much more, too bad. When you claim an account of profits, you claim the profits that have actually been made, not profits that could have been made. And in the same way, if you seek to make the claim via a constructive trust rather than the account of profits, the result should be the same. The constructive trustee is a bare trustee. He's not a trustee with active managerial duties. He's not under an obligation. Having stolen money from the company, he's not under an obligation then to invest it in some prudent way so as to maximise the company's ultimate recovery.
I mean, that would potentially be the logical consequence.
Yes.
And with an ordinary trust, the trustee has an obligation to invest and can be held liable if...
Lord, yes. It should be remembered, of course, that let's assume a case of a misapplication of corporate funds. The director steals £100 million from a company's coffers. The company, let's say the company was going to use that money to make a very profitable investment, which would have doubled its money over a period of 2 years. But because the money's gone, it can't. In that scenario, it would claim damages from, it would claim compensation in equity from the director. And the compensation it would claim would not just be the money that was misappropriated, it would be the loss it's actually suffered, namely the 200 million loss.
Yeah.
That's because in a way, it's the opposite of the substitutive claim argument that my learned friend wishes to. I think my learned friend would be forced to say, no, they'd be limited to a claim in 100 million. Well, that, in my submission, that's not right at all. In fact, it's a good example showing why it can't be right. But be that as it may, it would be open to the company to make its claim for 200 million, and then to claim a lien over the asset representing what the errant fiduciary has done with the money. So the errant fiduciary might have invested it very wisely and made 200 million himself. Then the company could claim the 200 million. He might have invested it very badly and lost some money and ended up with only 60 million. In that scenario, the company would claim 200 million compensation in equity and claim a lien over the 60 million that the trustee, I should say the fiduciary, has left in his hands. But what the claimant wouldn't do, what the company wouldn't do, would be claim, what would it claim? 100 million, and then claim that there's 60 million, but the director should have made more money. And in fact, if he had, he'd now have 200 million. That wouldn't be a claim that any rational entity would ever make. I hope that's not a complete answer because research hasn't been done, but Lord, that's our provisional answer to your Lordship's question.
Yeah, thank you very much.
Lord, now moving on to the third and final reason given by the learned judge for coming to his conclusion. He says, third, if the position of the corporate recipient of the property can be known, is brought into the analysis at this point, and is treated as having received the property beneficially, but with the fiduciary's notice attributed to it, then the payment of the profits away by the corporate body would be a breach of a Type 2 constructive trust, which arose by virtue of its knowing receipt. And if the dishonest assistant assisted that breach, it would be liable. I cannot see why a different result follows if, as is the assumed position here, the corporate vehicle receives as nominee for the fiduciary who committed a breach of the fiduciary duty in acquiring trust property and then uses the profits for their own purposes, the dishonest assistant assisting at both stages. Now, if Cambulo hadn't been a nominee, I accept it would have been a knowing recipient.
When you say knowing recipient, you talk about knowing receipt. That sounds like another species of constructive trust, for which you get a personal remedy. That's presumably not what's being talked about.
A knowing recipient is treated in all respects as if it were a real trustee. The only difference between a knowing recipient and an actual trustee is the Limitation Act.
You're getting into tricky territory here. There's a case called Birss, which has recently been heard in the Supreme Court.
Well, I'm afraid I'm not aware of that case. But thank you, I'll go and look. Assuming for the moment, I will have to go and look at that case, but assuming for the moment that there would be a claim for breach of the Type 2 constructive trust by the knowing recipient, if one were to assume that,
I don't know why you have to bring a knowing receipt into it at all, actually, or the judge has to. I mean, if you receive trust assets, not as equities, darling, then there is a trust. It's not a knowing receipt. Knowing receipt of itself refers to a species of personal liability. But there just is a trust. If you have the legal title and you don't have the beneficial title, then there's a trust. Someone else has a proprietary interest in the property.
I'm trying to reconstruct in my mind why I thought the judge's analysis when I read paragraph 288 was right. I'm sitting here, standing here now, listening to your lordship. I'm struggling to remember. Assuming that the...
I mean, it might be fine if you say if you don't attribute a technical meaning to the words knowing receipt.
Well, assuming that Cambulo is a trustee, a constructive trustee of some sort, the question would then be, and someone were to assist, someone who's involved in the original scheme, were to, instead of assisting Mr. Ruhan in dissipating the funds, because Cambulo technically owns the funds, he assists Cambulo in removing the funds. Would the result be any different? In my submission, not, for exactly the reasons I've already adverted to. It's the same scheme or course of conduct for the same purpose, just as it would make no difference to a conspiracy claim. In my submission, it would make no difference to a claim in equity. It's worth emphasising the flexibility with which equity approaches these novel situations of this kind to do what's fair, just and reasonable. Your lordship will have well in mind the speech of Lord Brown Wilkinson in Target, emphasising that common sense has to be applied in assessing loss. And your lordship will also have in mind the reference in Hulbert to Lord Justice Peter Gibson's judgment in the Court of Appeal in Attorney General and Blake as to the elastic rules of equity.
Can I just confuse myself a moment longer about looking at paragraph 288? So by type 2 constructive trust, he means a non-institutional trust.
Yes.
I don't think you can breach a non-institutional trust. I mean, you may be a trustee because you have the legal title and someone else has a beneficial title, and you may be capable of breaching that trust. But I don't at the moment see how you can breach a liability for knowing receipt, because a liability for knowing receipt is like a claim for damages.
My Lord, I'm not in a position to dissent from what your lordship has said, as I stand.
I mean, it's like saying, can you assist a claim for dishonest assistance?
There is first instance authority for the proposition that it's possible to dishonestly assist a breach of a knowing receipt category 2 type trust.
There is what is that?
They're not in the bundle.
Don't worry. Come back to it.
They're referred to in the judgment. In the judgment, it's paragraph 277. Perhaps if your lordship could pick it up at paragraph 276.
Yes, I see. Well, it's accepted there could be liability for dishonest assistance in relation to a type 2 constructive trust. I'd have no trouble with that if that meant that the person with the legal title didn't have beneficial title, but that doesn't obviously follow from there being a type 2 constructive trust. Anyway.
I'm afraid I can't assist you further. Of all the cases I've read in this case, I'm afraid I haven't read those ones.
Yeah.
So, Lord, I say that if Cambulo had not been a nominee, but had taken the property in its own right. In other words, if it had been used as a vehicle, instead of being used as Mr. Ruhan himself, instead had been used as a vehicle for Mr. Ruhan's interests, the result would be the same result that I've contended for in relation to Mr. Ruhan himself. And that is as a result of the flexibility with which equity approaches novel situations of this kind, novel arguments, if I can say so, of this kind. In terms of equity approaching, dealing flexibly with novel situations, perhaps I could advert your lordships to two authorities. The first one is in Bundle 7. Tab 51, the case of Auden Mackenzie. We'll come back to it later. And it's at paragraph 60, which is at page 2690. You'll see the full context later on, but I rely on these words of my Lord Justice David Richards, as he then was, halfway down the paragraph. No case of which counsel or the court are aware has raised facts as stark as these, whilst the decisions in Target Holdings and AIB do not directly assist Mr. Patel for the reasons I've given. They demonstrate a willingness on the part of the courts to develop equitable remedies for breach of trust and breach of fiduciary duty, and where required to do what is practically just, to entertain some departure from the strict obligations of trustees and fiduciaries to restore the fund under their control. This potential for flexibility has been emphasised in many cases and commentaries, not least Target Holdings, AIB, and Sinclair Investments and Versailles in the Court of Appeal, which is not in the bundles today, but it's quite a well-known quotation. Already in this situation, flexibility would be appropriate, and the appropriate result would be that for which I've submitted. I now come to my learned friend's attempt to rely on the concept of substituted compensation as supporting his analysis of the law. He argues that the judge's decision on equitable compensation here should be upheld on the basis that there is a distinction between the two types of equitable compensation: substitutive performance claims, in which the trustee is required to make a money payment as a substitute for performance of his obligation to produce his trust assets in specie when called upon to do so, and reparative claims, which are claims for a money payment to make good loss caused to the trust by the breach. It should be made clear this distinction did not form any part of the judge's reasoning. In my submission, that distinction is a red herring here. It's part of the interminable argument, which is still sometimes you still see going on, in which the Supreme Court keeps telling us that claims for misapplication of trust property are still claims requiring actual loss to be assessed, and in a common sense way. Academics and textbook writers, or some textbook writers, find it impossible to relinquish the notion that, based on the historical process of accounting by trustees, that where a trust money is misapplied, the trustee comes under an immediate liability to restore the trust fund, and that case creates a sort of restitutionary right or equitable debt, which conveniently allows the trust, if it's still being administered, or the beneficiaries, if they're now absolutely entitled, to claim more than the loss that they have actually suffered. In my respectful submission, the equitable debt argument has been comprehensively rejected as a matter of English law in Target and Redfern's, first of all, and more recently by the Supreme Court in AIB and Redler. This is explained very well by Lord Burroughs in his Remedies for Torts, Breach of Contract and Equitable Wrongs, which I invite the court to read. So it's lengthy, but it repays study. It's in the bundles. It's in Bundle 8 at tab 59. I invite the court to read it. It's also dealt with very well by Professor Worthington in her illuminating article, 4 Questions on Fiduciaries. That's in the Authorities Bundle at Bundle 9 at tab 79. And again, I invite your lordships to read it. She rather aptly calls advocates for the substitutive approach, she calls them dissentients. And in my respectful submission, that's the right name for them. If it is necessary to resolve this question on this appeal, the starting point should be these texts. However, in my submission, it is not necessary to do that. I'm bound, of course, to deal with HP2's arguments, but the first point I wish to make is that those arguments have no bearing on the issue for this court. The cases which HP2 relies upon are about what happens when it's been established that funds have been misapplied from a trust. This case is about whether it's right to regard funds as having been misapplied in the first place. Whether, as against the trustee and the dishonest assistant, it's right to characterise what has occurred as a misapplication of trust assets, as a loss of trust assets. In any event, I say HP2's analysis is flawed because it mischaracterises the nature of HP2's claim, and it's incompatible with the leading cases on equitable compensation, namely Target and AIB. Those are both misapplication cases. They make it clear that the question to be asked is whether, on a common sense view, the trust can be said to have suffered a loss in respect of which equitable compensation is to be awarded. Perhaps we could have a quick look at AIB. I'm afraid the version in the bundle isn't the law report, and I can only apologise for that. It's at bundle 6, behind divider 41. We do have law reports available, should your lordship.
Certainly, I would welcome a law report at some stage.
Could I hand it up now?
Please.
it was another mortgage situation. AIB was lending money for a purchase of property. By mistake, the solicitors who had AIB's money used that money to pay off only part of the vendor's mortgage debt owed to Barclays, releasing the rest to the borrowers. The result was that Barclays maintained a first charge, securing a debt of $273,000 over the property being purchased, with the result that AIB, instead of being a first chargee, only had a second charge, which was postponed to the extent of $273,000. The property market fell, with the result that AIB lost not $273,000, but it lost $2.5 million because of the fall in the property market. So the counterfactual question in that case was a hypothetical one. What would have happened if the £273,000 had been paid off? AIB ran a case seeking to reinterpret Lord Brown Wilkinson's judgment in Target so as to allow it to make a substitutive equitable debt type claim. Money had been paid out, there was an immediate duty to restore, the only credit allowable is the ultimate proceeds of sale. The Supreme Court gave this argument short shrift. Lord Toulson, perhaps I could pick it up at paragraph 33 of his judgment. It's at page 2299 of the bundle that your lordships may be using, the actual report. Could I invite your lordships to read paragraphs 33 and 34 of his judgment? Or in fact, all the way through to 36.
Yeah.
So if we could pick it up at paragraph 49, Lord Toulson said, the determination of this appeal involves two essential questions. The more important question is whether Lord Brown Wilkinson's statement in Target of the fundamental principles which guided him in that case should be affirmed, qualified, or as the bank would put it, reinterpreted. And then, Lord, in paragraph 50, he identifies two main criticisms have been made of Lord Brown Wilkinson's approach. They've been made by a number of scholars, most recently by Professor Mitchell. He described the reasoning as incoherent and expressed the hope that if the case reaches the Supreme Court, their lordships will recognise that Lord Brown Wilkinson took a full step in Target when he introduced an inapt causation requirement into the law governing substitutive performance claims. So your lordships will see this is a full frontal attack on the Target approach with the equitable debt type argument. And if one goes over the page, you see in paragraph 51, the primary criticism is that Lord Brown Wilkinson failed to recognise the proper distinctions between different obligations owed by a trustee and the remedies available in respect of them. The range of duties owed by a trustee include the custodial stewardship duty, the management stewardship duty, and the duty of undivided loyalty. 52, we then see the reference to historical accounting. Your lordships will all be familiar with this. 53, Lord Toulson says rather amusingly, according to legal scholars whose scholarship I have no reason to doubt, in the case of a breach of the custodial stewardship duty through the process of an account of administration in common form, the court would disallow or falsify the unauthorised disposal and either require the trust fund to be reconstituted in specie or order the trustee to make good the loss in monetary terms. The term substitutive compensation has come to be used by some to refer to a claim for the value of a trust asset dissipated without authority. And then it says breach of a trustee's management duty is different. There you need willful default, which actually doesn't mean willful default. But what you argue is that the trustee should have done more, and he should make good the loss that suffered as a result of his not doing more. And that's called, the academics call that reparative compensation. 55, in the case of a breach of the duty of undivided loyalty, there are possible alternative remedies. If the trustee is benefited, the court will order him to account. In Bristol and West, Lord Justice Millett describes such relief as primarily restitutionary and restorative. Then at 56, his lordship says the history of the account of profits is more complex than this summary might suggest, and the whole concept of equitable compensation has developed and has become far more prominent in the law since Nocton and Lord Ashburton. However, this is sufficient to identify the main criticism advanced against Lord Brown-Wilkinson's approach. It said he treated equitable compensation in too broad brush a fashion, muddling claims for restitutive compensation with claims for reparative. And then you see the essence of the argument in 57. The relevant principle it suggested in a case of unauthorised dissipation of trust funds is that the amount of the award is measured by the objective value of the property lost, determined at the date when the account is taken and with the benefit of hindsight. That's the equitable debt analysis, as it can be called. In determining the value of what's been lost, the court must take into account any offsetting benefits received, but it's not relevant to consider what the trustee ought to have done. The court is concerned only with not the net value of lost assets. So the whole purpose of the substitutive performance line of argument is to allow claimants to be overcompensated. It's to allow claimants to achieve financial recompense which exceeds the loss that they can truly and in common sense terms been said to have suffered. And that's done by preventing the court from considering the position that the claimant would have been in had the defendant actually complied with the duty that was breached. On the equitable debt analysis, you just don't ask what would have happened if he'd done his job properly. What you do is you say, look, there's this immediate loss to the fund. If some money comes in as a result of the mortgage, fine, but anything else, it's entirely irrelevant. I've got my £2.5 million claim. Lord, then in paragraph, let's come to the conclusions. Paragraph 62, there are arguments to be made both ways, as the continuing debate amongst scholars has shown. But absent fraud, which might give rise to other public policy considerations that are not present in this case, it would not, in my opinion, be right to impose or maintain a rule that gives redress to a beneficiary for loss which would have been suffered if the trustees had properly performed its duties. Well, that was the ratio in Target. That was the reasoning that was attacked in AIB, and in AIB, Lord Toulson and indeed the rest of the court upheld the Target approach. And then perhaps I could invite your lordships to read paragraphs 63 and 64. Picking his judgment up at paragraph 65, he says the purpose of a restitutionary order is to replace a loss to the trust fund which the trustee has brought about. To say that there's been a loss to the trust fund in the present case of 2.5 million by reason of the solicitor's conduct, when most of that sum would have been lost if the solicitors had applied the trust fund in the way the bank instructed them to, is to adopt, and I do emphasise this language, an artificial and unrealistic view of the facts. In Target, Lord Brown-Wilkinson said, you've got to apply, first of all, you've got to look at real loss caused, and secondly, you've got to apply common sense in coming to a conclusion. Here, Lord Toulson talks about artificial and unrealistic, you must avoid artificial and unrealistic views of the facts. Paragraph 66, I would reiterate Lord Brown-Wilkinson's statement, echoing Maclachlan J's judgment in Canson, about the object of an equitable monetary remedy for breach of trust. And that's where, your lordships will recall, he talked about it's a compensatory principle. Whether it be subclassified as substitutive or reparative, even if you want to call it substitutive, it's still about loss. Compensation for loss. As the beneficiary is entitled to have the trust property administered, so he's entitled to have made good any loss suffered by reason of a breach of the duty. Then and then, Lord, over the page to paragraph 73, or perhaps 72 and 73, it's argued that the case falls within Lord Brown-Wilkinson's statement that until the underlying commercial transaction has been completed, the solicitor can be required to restore the client account monies wrongly paid away. This argument constricts too narrowly Lord Brown-Wilkinson's central reasoning. Monetary compensation, whether classified as restitutive or reparative, is intended to make good a loss. The basic equitable principle applicable to a breach of trust, as Lord Brown-Wilkinson stated, is that the beneficiary is entitled to be compensated for any loss he would not have suffered but for the breach. In this case, proper performance of the obligations of which the trust formed part would have resulted in the solicitors paying to Barclays the full amount required to redeem the Barclays mortgage, and as Lord Justice Patton said, the bank would have had security for an extra £300,000 or thereabouts of its loan, and that was the measure of its loss. And Lord Reed agreed, so picking his judgment up at paragraph 78, he says, I agree this appeal should be dismissed. I've reached that conclusion for the reasons which are substantially the same as those of Lord Toulson. And then at paragraphs 100, there's a long exegesis, and I don't have time to take your lordships through it, but if I could go straight to the end. Paragraph 133, the heading General Conclusion. He says, notwithstanding some differences, there appears to be a broad measure of consensus across a number of common law jurisdictions that the correct general approach to the assessment of equitable compensation for breach of trust is that described by Mr. Justice Maclachlan in Canson Enterprises and endorsed by Lord Brown-Wilkinson in Target Holdings. In Canada itself, Mrs. Justice Maclachlan's approach appears to have gained a greater acceptance in the more recent case law, and its common ground that equitable compensation and damages for tort or breach of contract may differ where different policy objectives are applicable. Following that approach, which I've discussed more fully above, the model of equitable compensation, where trust property has been misapplied, is to require the trustee to restore the trust fund to the position it would have been in if the trustee had performed his obligation. If the trust has come to an end, the trustee can be ordered to compensate the beneficiary directly. In that situation, the compensation is assessed on the same basis, since it's equivalent in substance to a distribution of the trust fund. If the trust fund has been diminished as a result of some other breach of trust, the same approach ordinarily applies. The measure of compensation should therefore normally be assessed at the date of trial with the benefit of hindsight. The foreseeability of loss is generally irrelevant, but the loss must be caused by the breach of trust in the sense that it must flow directly from it. Losses resulting from unreasonable behaviour on the part of the claimant will be adjudged to flow from that behaviour and not from the breach. And perhaps I could finish off by taking the court to paragraph 140. Halfway down, there's a sentence beginning the second fallacy in AIB's argument. I don't know if your lordship see that. He says, the second fallacy in AIB's argument is that it assumes that the measure of Redler's liability was fixed as at the date of the breach of trust, a proposition that was rejected in Target Holdings and in the Commonwealth authorities which I have cited. The third fallacy is that the argument assumes that liability does not depend on a causal link between the breach of trust and the loss. Redler is sought to be made liable for the consequences of the hopeless inadequacy of the security accepted by AIB before its involvement, despite the fact that Redler's breach of trust didn't affect that security except to the extent of 309,000 and finally of 273,000. That proposition was also rejected in Target and in the Commonwealth cases. In these circumstances, applying the approach to the assessment of compensation which I've explained, it appears to me that the loss to the trust estate as a result of Redler's breach of trust proved to be £273,000. I'm sorry to have taken that at some length. These are long judgments and it would be possible to take it at much greater length. But what those cases say, what they establish, is that whether you characterize the claim as a substitutive claim or a reparative claim, you still have to consider what loss has been caused by the breach. For that purpose, it's necessary to determine what counterfactual you choose, so as to compare the position before and the position after. The counterfactual assuming no breach. These cases don't touch on the question I addressed this morning, which is that in what circumstances does that counterfactual include earlier breaches? And I've addressed the court on that question already. As I say, so I can't pretend that Target and AIB help me on that question, but the important point is that they don't hurt me on that question either. What they do say, which in my submission is helpful, is that a common sense approach has to be adopted to the question of loss, rather than an artificial and unrealistic one. This is why I say that these cases are a red herring, and that is my first reason for submitting that they should be rejected in the court's analysis of this case. My second reason is the fact that HB2 tries to characterize this case as a misappropriation case because, of course, it says the only breach of duty you take into account is the custodial breach, and that's a dissipation of trust assets. Therefore, it's misappropriation. Therefore, we can run the substitutive analysis. But applying the principles I've explained, that's a mischaracterization. If one has to mischaracterize this case, I say one doesn't, but if one had to, it's an unauthorized profits case. It always has been. The crux of HB2's complaint, from which this entire case arises, is that Mr. Ruhan breached his fiduciary duty by failing to disclose his interest in the sale of the hotels to Cambulo and by making and retaining a profit from it. This is not a case in which a fiduciary misappropriated existing trust assets. Properly understood, taking into account the earlier breach, Mr. Ruhan bought the hotels through his nominee for a market value, and the purchase contract was never rescinded. For both these reasons, I respectfully submit that HB2 is wrong to treat this case as analogous to interactive technology in First and the second case of Auden, Mackenzie and Patel. In those cases, a delinquent director misappropriated company money by causing it to make unauthorized payments to him for which he had given no consideration. In such cases, the director is usually held liable to pay compensation equal to the amount misappropriated. The absence of consideration, or perhaps the inadequacy of consideration, is key in those cases. But here, of course, Mr. Ruhan paid market value for the hotels. It suffered no loss as a result of the transaction. That's why we're here arguing all about this new analysis. Before I leave the point, it might be helpful if we do look at one of the other cases, the most recent case, the case of Auden Mackenzie. That's in the bundle 7 at tab 51. Auden Mackenzie was a case where a director and his sister owned a company, quite a substantial company, and they were its sole directors. They were the Patels. The brother paid money out for the benefit of both of them, but instead of declaring lawful dividends, he paid them out on the basis of false invoices, so as to allow the company to avoid corporation tax, and he and his sister to avoid income tax. The company, now in separate ownership, made a claim for the payments. It didn't claim the fact that it was subjected now to tax penalties and interest for what had happened. It claimed the payments themselves. The defendant argued that he wasn't liable to pay equitable compensation in a sum equivalent to those unauthorised payments because if he'd not acted wrongfully, he and his sister could and would have procured that the money would have been paid to them by way of lawful dividend, so that the company had therefore suffered no loss. There was a summary judgment application, which of course required the court to assume the truth of that averment. The judge granted summary judgment, the defendant appealed to the Court of Appeal. The judgment of the court was given by, the leading judgment was given by Lord Justice David Richards. He didn't hold that the defendant was wrong. He concluded that his argument was not unsustainable at law. So this isn't an authority in favour of the substitutive approach, even in that narrow category of cases of theft of assets by directors from their companies. But it is interesting to see how he dealt with the argument based on Lord Brown-Wilkinson's judgment in Target. If I could pick it up at page 2688. So in paragraph 50, we have Mr. Christopher Pymont relying on statements in judgments in Target Holdings. In paragraph 51, Lord Justice David Richards says, in my judgment, these statements don't support Mr. Pymont's broad submission. They're not directed at the effect that hypothetical intervening events might have on the claimant's loss. That meaning is as illustrated by what Lord Brown-Wilkinson said. The quantum is fixed at the date of judgment, at which date, according to the circumstance then pertaining, the compensation is assessed at the figure then necessary to put the estate back into the position it would have been in had there been no breach. As already mentioned, the point is illustrated by Lord Brown-Wilkinson's citation of Reed Dawson. If the amount required to replace the misappropriated asset is less or more at the date of the trial than it was at the date of misappropriation, either as a result of changes in its value or the grant of security, it is that amount which will be awarded as compensation. This was extended in AIB to the limited extent discussed above. Lord, stopping there, when he says the limited extent discussed above, he's discussing the fact that in AIB, what would have happened was a hypothetical. In Target, the money had, the mortgage had actually come in. Only it came in late. It came in after the money had been dispersed to the purchaser. In AIB, the money was never properly applied, so the court had to decide hypothetically what would have happened if the Barclays mortgage had been paid off. And then,
just so we're clear what we're talking about, should we identify the broad submission? Since the judge says that the statement states support Mr. Pymont's broad submission.
The broad proposition, it's in the first sentence of paragraph 50, second line, the broad proposition that in identifying the loss caused by a misappropriation of trust assets, the court looks at the claimant's position at the date of trial and compares it with its position immediately following the misappropriation. If the claimant would not in any event have the misappropriated asset or funds in any valuable assets in their place at the date of trial, the claimant has suffered no recoverable loss. So, for example, then there's a reference to the various passages that Mr. Piemont relies on. That's the broad proposition.
So at this stage, the argument is if the company would have given the property away in one way or another, so that it would have been no better off.
Yes.
There's no relevance.
That was the argument.
Yep.
And then Lord Justice David Richards says at paragraph 53, the fallacy in Mr. Piemont's broad submission may be shown by the example put in argument to him. If one supposes that the shareholders of the company had been a different body of persons from the directors, would a claim against the directors who'd misappropriated company funds be rejected if it were established that, if the funds had not been misappropriated, they would have been paid as dividends to the shareholders? In that case, the effect of the misappropriation is to deprive the company of funds which it would otherwise have been free to apply as it, whether acting by its shareholders or by its directors in accordance with their duties, thought fit. That could, of course, include the payment of dividends to shareholders or of charitable or other donations to third parties. The company has suffered a real loss measured by the amount misappropriated, and it's no answer at the date of trial that the company wouldn't have had those funds. Lord, what that may be approaching is a landing ground in this curious area of law. Up until Auden Mackenzie, there appear to be two lines of authority that appear to have an independent existence. On the one hand, there was Target and there was AIB, which said it's loss-based. And then there were the unlawful distribution cases, including, of which this is the culmination, in which it was alleged that where a director misappropriates assets, where, for example, he makes a distribution out of capital or otherwise, then in those circumstances there's an immediate loss, and it's a real loss of the amount that he has misappropriated. You don't go into their further questions as to what would have happened. And those two lines of cases are like ships passing in the night. The latter cases talk about substitutive compensation as if it's an answer to the target problem, although, as I've sought to show to your lordships, it isn't. What's interesting about Auden Mackenzie is it begins to suggest that there may actually be a resolution, a landing site for this divergence in approach. It may be that the company, in a circumstance where there's been a misappropriation, it may be that the company would have lost the money in speculation, or it would have given the money away, assuming it was allowed to do that. But it was not in any way bound to do so. So in those cases, it could be said that the company had a choice of what to do with its money. That choice was taken away from it. That choice represents a real loss. The fact that it might have given the money away is res inter alios. So it may be that we're moving very slowly towards that answer to this particular problem, the problem of directors misappropriating funds. But, my lord, that problem is not this problem. It doesn't arise in this case.
No, I mean, I was in this case, Auden Mackenzie.
Ah.
My recollection is that argument always seemed completely hopeless. Because it's like saying, I've cheated you of £1 million. Actually, if you'd had £1 million, you'd given it away to your daughter. Therefore, you suffer. You're no worse off. I mean, that was always hopeless. Lord Justice David Richards goes on to consider other arguments, which may or may not be more relevant, but he didn't stop at that point.
No. Well, my lord, I'm not going to go on in this judgment. I'm not proposing to do so, simply because it's a really interesting problem, and it raises some issues that do need to be wrestled with.
I mean, the next argument, I'm not sure this helps either, but the next argument was, well, actually, what matters is that the company would have given us, the defendant and his sister, the money by payment of dividends. And that's not the argument that was the broad submission.
Yes. My lord, let's imagine two different. I'm now arguing Ord and Mackenzie, not even having realised that you actually were in that case. Imagine a case where a company has adopted a firm decision to pursue a particular investment policy, and it's prevented from carrying out that decision because money has been taken away from it. History then reveals that the company, if it had gone ahead with its decision, which it certainly would have done, it would have lost its shirt. Now, in that situation, does it get the windfall of recovery of the money, but by the happenstance that the director stole the money in the first place? That's an interesting question. The facts here were interesting too, because it was actually true. It seemed a very powerful argument. These people were the sole directors and shareholders of the company. They wanted the money from the company, and it's fair to say that they could and would have procured that the company gave it to them. And it's for that reason, that because the facts were so strong, that his lordship decided that although he as your lordship says, was entirely unsympathetic either with the broad or the narrow proposition, he says in paragraph 60 at page 2690, this is the passage we've already looked at, the assumed facts are striking. Mr. Pymont is right to say that the position of all parties would by now have been precisely the same as it was immediately after the payments were made. The company would not have the money, and Mr. Patel and his sister would have received the money, whether directly or through companies controlled by them. However, moreover, as the only shareholders, Mr. Patel and his sister were able at all material times to procure that result. No case of which counsel or the court were aware has raised facts as stark as these. While the decisions in Target and AIB don't directly assist Mr. Patel for the reasons I've given, they do demonstrate, and this I do pray and aid, they do demonstrate a willingness on the part of the courts to develop the equitable remedies for breach of trust and breach of fiduciary duty, and where required to do what is practically just, to entertain some departure from the strict obligations of trustees and fiduciaries to restore the fund under their control.
So just to be clear, I don't know if this case is relevant at all, but if you're saying, well, Target and Redferns and AIB and Redler are really determinative in this sort of area, you say, do you, that Mr. Patel had a knockout point to the claim against him because had he not taken the money using false invoices, he would have received the money anyway by payment of dividends?
Lord, I don't make that submission in relation to this case. What I say is no more than the company didn't have a knockout point. And this case, this appeal, doesn't require you to decide whether the point was a knockout point or not.
And I follow that. I don't know that at the end of the day it's the difference between substituted and reparative compensation, or whether you can have a distinction, is going to matter. But Mr. Pickering obviously relies on this. You say, well, the distinction has been blown away by Target and AIB, and subsequent decisions where there's been reference to the distinction are wrong, I suppose.
Well, I say that in order for there to be, whether one chooses to characterise a claim as substitutive or reparative, the compensation that is awarded must be awarded in respect of loss that's actually been suffered. And in determining what loss has actually been suffered, one has to ask the question, what would have happened had the defendant complied with his duties? And Lord, I go further on the facts of this case because of the close connection between the fiduciary duties and the custodial duties arising from them. I say that when the court decides, makes a judgment as to what would have happened had the director complied with his duties, one has to assume that the director complied with all of his relevant duties, including the duty to disclose his interest in Cambulo when the contract was entered into with Cambulo. And if there had been full disclosure, there would have been no secret profit, and the company wouldn't have lost a penny piece.
I just had one footnote to all this. You've invoked Dame Sarah Worthington, and you rely on her article. I know, at least I think I know, that there's a case note on Auden Mackenzie by Dame Sarah Worthington, where I think she's doubtful about the decision, but doubtful on the basis that Mr. Patel probably shouldn't have had an answer to the claim at all. Which might be thought more consistent with Mr. Pickering's approach on this particular point.
Well, Lord, as I say, because of the close relationship between the two, I'm even hesitant to say they're two breaches. It's unrealistic, it's artificial and unreal to treat them as if they were two breaches in some kind of distinct sense. They're not distinct. They can't be considered except together. And even if Mr. Pickering is right, if you consider them together, two consequences follow. The first one is that the breach, to understand the case, the real breach in this case, the real nub of HB2's claim, is not that there was a breach of the ultimate constructive trust that arose. It was that there was a failure to disclose Mr. Ruhan's interest in the Cambulo contract. That was the breach. That wasn't a misapplication breach. It was a non-disclosure breach.
Yeah.
And secondly, if one takes both breaches into account and considers them in the round, one sees that there hasn't been a misapplication of assets at all, because there would have been no secret profits to misapply. We're left with the point that the company suffered no loss as a result of Mr. Ruhan's actions. Mr. Ruhan is held liable to account for his profits, but that's because he's a trustee. No one else in this case is. Mr. Stevens isn't. Yeah. Lord, my learned junior has suggested we look very briefly at is it Dame Sarah Worthington? I wasn't aware.
Yes. Or Professor Worthington. She is both.
It's at page 3052, which I think it would be bundle 8. I'm so sorry, it's Burrows. Oh, right. It is Professor Burrows. Bundle 8. And he refers to, so it's behind divider 59. It's page 3052. Here, Professor Burrows is talking about target. You can pick it up at the bottom of 3051. In the former case, that's target. The defendants were solicitors who were acting for mortgagees in relation to the purchase of property, a breach of trust, the defendants paid over the loan money, and so on.
But I wasn't keeping up. Just remind me where you are.
I was at the bottom of it's bundle 8,
yes.
Tab 59, page 3051.
Do you know, I don't seem to have numbers at the bottom of the page on this one.
Oh, I'm so sorry. You're right. It's page 516 of the.
Yep.
I do apologise.
Yes.
At the sort of top of 3052, halfway down the first paragraph, the House of Lords agreed, and it's in target, and held that there could be no equitable compensation, and although this was implied rather than expressly stated, no account remedy, whereas on these facts, the loss would have been suffered even if there had been no breach of duty. However, applying the argument of Birks, Millett, Elliott, Mitchell, and Edelman, the House of Lords should have taken a different approach to the supposedly separate account remedy than to equitable compensation, even if ultimately the same result might have been reached on the facts. Precisely because, like an action in debt or specific performance, the account remedy doesn't require loss to have been caused by the breach of trust, the fact that the beneficiaries would have suffered the loss in question, irrespective of the breach, should have been irrelevant. And then he says this, while historically it may be that the account remedy was viewed in this way, it's hard to see why logically, or as a matter of policy, one would wish to retain a distinctive remedy of that type. Why should one regard a trustee who has without authority paid money out of a trust fund as having a continuing positive duty to restore the trust fund to where it was prior to the payment out, even though the same loss would have been suffered even if the trustee had complied with its duty? A trustee does not normally undertake to pay a particular sum to the beneficiaries, so there's no direct analogy to a contractual debt claim. And it's misleading to separate out one part of the trustee's duties as if there is a continuing duty to maintain the trust fund, irrespective of the trustee's other duties or what has subsequently happened. True it is that one is seeking to replicate by a monetary remedy the required performance of the trustee not to make an unauthorised payment from the trust fund, just as where one compensates for loss of breach of contract. But the essential point is that had the trustee properly performed its duties, the beneficiaries would still have suffered the loss to the trust fund. One ought not artificially to freeze the trustee's duty and performance at one point in the past, thereby ignoring the trustee's other duties and the other facts relevant to the working out what the claimant's loss has been. Stopping there, he's not simply making the stopping the clock point. You can't stop the clock when it suits you. He's also making a point that one has to take into account all of the trustee's duties, everything that it had to do. And I say that's right, and I say that principle is applicable in this case because of the intimate connection between the constructive trust and the original fiduciary duty which the constructive trust supports.
So just coming back, I think, to where you were, and I have to say, I'm very hopeful that at the end of the day this case will not turn on this argument. But so suppose director pinches £1 million in circumstances where the board had resolved the day before that they would invest the £1 million in, I don't know what, some company that subsequently failed. You say clearly following target and AIB, the company has no claim in respect to the £1 million that was stolen.
I say it's difficult, but let me take it in stages. If the director had stolen the money while it was on its way to the investee, the hopeless investee, I say clearly there'd be no liability in that case. And because the money had he not stopped it going, it would have gone to the investee and it would have been lost. Why should it make a difference that he stole the money when it was in the account waiting to be passed out to the investee? But more fundamentally, I also say that none of my arguments depend upon the answer to the question your lordship has asked. The difference and the difficulty that's raised is that in these cases, the counterfactual that one is debating is a counterfactual in relation to which the company, the claimant, has no obligation to act, or in relation to which there's no relevant obligation to act. So, in a real sense, you could say that the company has been deprived of its freedom to do what it wants with its money. If I want to give my mother £1 million, and you stop me doing that, why on earth shouldn't I get £1 million from you? I still want to give my mother £1 million. So that has a kind of a moral weight, if nothing else, at point. It's different, and in fact, the difference is to be seen in the example at the bottom of this page. The difference is that where there's an obligation on the trustee, where the trustee was obliged to do something else that would have caused loss to the trust, but instead he stole the money. In that situation, it would be madness on stilts if the trust was still to recover compensation for the amount misappropriated. And the point is that in making any kind of loss analysis, one has to determine what was required by the trustee's other duties. And this example, it's a Sarah Worthington example. Sarah Worthington makes the same point and illustrates its force by an example. Say a trustee takes £1 million from a trust fund for its own use and uses it non-traceably. assume that what it should have done, according to the trust deed, was invest these particular funds in shares which would now be worth £500,000. According to Worthington, it's inappropriate to regard the beneficiaries as having a remedy which requires the trustee to restore the trust fund by paying £1 million. That is to concoct a duty to restore the funds, whereas the correct analysis was that there was an ongoing duty to invest the funds in shares. It is to that ongoing duty that the remedy must respond, and the equitable compensation remedy, responding to the loss of the trust fund, would correctly lead to an award of £500,000. As Worthington writes, excuse me, the beneficiary could claim equitable compensation for breach of trust, requiring the trustee to restore the trust fund to the state it would have been in if proper performance had been delivered. Now, I say that is relevant to my analysis, because when Professor Worthington says proper performance, that would include, in this case, proper performance of the fiduciary's obligation to disclose his interest in Cambulo. That's part of the counterfactual. You don't just assume breach. Sorry, you don't just look at the individual breach on its own. You look at everything, and you work out what would have happened if the right thing had been done throughout the single course of conduct that is under consideration. So, Lord, there's some one point that we make in our skeleton that I should correct, and that's in relation to Gwemba Valley. It's addressed in paragraph 38 of our skeleton, which is in the core bundle behind divided 2 at page 27. We say that if the judge's analysis, if the learned judge analysis in our case is correct, we're right, the claimant in Gwemba Valley would have succeeded on its claim for equitable compensation against the defendant, Mr. Koshy. Well, that's not quite right, and I need to correct it. I can do it quickly. Yep. Gwemba Valley was a claim by the company, whom I shall call GVDC, against its director, Mr. Koshy, for breach of fiduciary duty, of which he was director. He was held accountable for the profits he made from his breach, but he was not held liable for any compensation, because the transaction that he procured the company to enter into, which was a series of loan transactions with a company in which he had a substantial shareholding called Lasco, because that breach caused no loss. The trial judge ordered the defendant to account for the profits, but he dismissed the claim for equitable compensation on the basis that the company would still have entered into the loan transaction even if the defendant had disclosed his personal interest in them. The company had therefore suffered no loss. This decision was upheld in the Court of Appeal. I don't have time to take your lordships to it, but I don't say that if the learned judge were right, the result in Gwemba Valley would have been different. But I do say there's an analogy. The crux of Mr. Ruhan's wrongdoing was the non-disclosure of his personal interest in the Cambulo sale and the unauthorised profit made by him from that sale. The appropriate remedy for that is an account of profits, which is what HB2 asked for and got in this case. HB2 suffered no loss as a result of Mr. Ruhan's failure to disclose his interest in the transaction. If he had disclosed it, it would either have gone ahead with the sale anyway or sold the hotels for someone else for the same amount. Now, the following points are worth making. GVDC sought an award of compensation in respect of all the payments it had made to Lasco, that's the third company, a company controlled by Mr. Koshy, in relation to the pipeline transactions on the basis that it was entitled to be put in the position it would have been in had it not entered into those transactions. Now, it had previously obtained summary judgment on a claim that Lasco held those payments on constructive trust for it. So we have a situation where Mr. Koshy procures the company that enters into a contract with his company, Lasco. He's in breach of fiduciary duty. Lasco is held to be a constructive trustee of its profit, the benefit it obtained from that contract. By the time of trial, the money paid to Lasco had been dissipated by Mr. Koshy via his control of Lasco, and Lasco was now in liquidation. So that trust fund had gone. Accordingly, there was no longer any specific fund in respect of which GVDC could assert a proprietary interest. Now, in Gwemba Valley, what GVDC wanted from Mr. Koshy was compensation reflecting all the payments it had made to Lasco. At trial, that claim failed because it could not show that it had suffered any loss as a result of the transactions for the reasons I've explained. So that's why it only got an order for an account of profits. But if HB2's argument were correct, GVDC would have succeeded on a claim for equitable compensation against Mr. Koshy as the dishonest assistant. It had obtained an order that Lasco held the payments on constructive trust for it. Those payments had been dissipated by Mr. Koshy through his control of Lasco. The important point is that this analysis doesn't appear to have occurred to anyone in that case. Not the trial judge, not the claimant, nobody. That is the point I should have made in our skeleton. Would your lordships give me a moment? Lord, it is worth referring to my skeleton for one paragraph in Gwemba Valley. If I could ask your lordship to go to page 37 of our skeleton, where it quotes paragraph 159 of the judgment of the Court of Appeal in Gwemba Valley. It's paragraph 37 of the skeleton.
Page 27, I think.
I'm sorry, I don't have the page number. Thank you. It's where Lord Justice Mummery, giving the judgment of the court, said, in our judgment, Miss Justice Reimer was entitled to refuse to order equitable compensation on the factual basis that he was not satisfied the loss had been caused to GVC as a result of the breaches of duty by Mr. Koshy. The crux of Mr. Koshy's wrongdoing was non-disclosure of his personal interest in the pipeline loan transactions and the unauthorised profit made by him from the transactions. The appropriate remedy for non-disclosure is to make him account to GVDC for that profit. It is not appropriate, if GVDC so elected, to require him to compensate GVDC for losses suffered in the venture when the probabilities are, as the judge on the evidence found them to be, that disclosure by Mr. Koshy of his interest would have made no difference to what GVDC would have done. Now, I do ask forensically if the substitutive performance analysis is correct. Why would what the company would have done be relevant? And the answer is because the crux of Mr. Koshy's wrongdoing was non-disclosure, causing a payment out of funds. And I say in this case, the crux of Mr. Ruhan's wrongdoing was non-disclosure as well. So, well, finally on this distinction, to the extent that there is a distinction between substitutive and reparative cases, if HB2's arguments were accepted here, it would effectively collapse that distinction. In every unauthorised profits case, the profits are impressed with a constructive trust in favour of the principal. That constructive trust goes hand in hand with the fiduciary's liability to account for his profits. The liability to account and the constructive trust have the same justification as each other, and the latter supports the former. They are inseparably or inextricably connected to one another. if the delinquent fiduciary has used them for his own benefit, the profits, in breach of his custodial duty as a constructive trustee, the principal would always be entitled to claim equitable compensation from the trustee on the substitutive performance basis in an amount equivalent to the profits so used. And this, as I say, this would collapse the distinction which my learned friend is anxious to draw, and it would create particular difficulty with dishonest assistance, as I'll address when dealing with novoship. We are not aware of any case in which a claim for equitable compensation on the basis advanced by HB2 has ever been raised, let alone succeeded. And we say HB2's analysis is incompatible with Target and AIB because these cases establish that the purpose of any award of equitable compensation, whether substitutive or reparative, is to make good a loss that's actually been suffered by the beneficiary, taking into account or on the basis that the trustee complied with all the relevant duties to which the trustee was subject. So, Lord, we say that this approach goes both for stopping the clock in the Target case, but artificially halfway through, and it also goes for starting the clock artificially halfway through as well. Now, that brings me to my second ground. I see that time is running. Ground two is simply that the conclusion reached by the learned judge was inconsistent with novoship. In novoship, this court held that the remedy of an account of profits in certain circumstances is available as against a dishonest assistant. But a number of differences, important points. The dishonest assistant is accountable only in respect of profits which he himself has personally received as a result of the assistance. He cannot be made to account for the profits received by the fiduciary as a result of his assistance. Important point. It's an important point, both in relation to this ground of appeal and also in relation to compound interest. We'll come to that tomorrow. In novoship, this court further held that there must be a causal connection between the assistance and the profits received by the assistant. The connection is not between the fiduciary's breach and the profits, it's between the assistance and the profits. And the court further held that in determining whether such a connection exists, the common law rules of causation, remoteness, and measure of damages apply by analogy. So one doesn't apply equitable rules. Furthermore, this court held that the fiduciary is not entitled to an account of profits from a dishonest assistant as of right. The court has a discretion whether to grant or withhold the remedy. And in his judgment, the learned judge referred to that as a strong discretion, not the traditional discretion that the court always has to withhold any equitable remedy when it's disproportionate in the circumstances. So what's important to understand from novoship is both the nature and extent of the dishonest assistant's liability to account for his profits are very different from the nature and extent of the fiduciary's liability. They're not the same at all. And they're very different because, as the court itself emphasised, fiduciaries are in a very different position from dishonest assistants. They're subject to special rules and special disabilities which strangers to trusts are not. So if we could have now go to the case, it's in bundle 6, behind divider 40. So the facts were as follows. The 6th and 8th defendants were held liable for dishonestly assisting the claimant's manager in awarding charter parties to the 8th defendant at market rates. So the manager breached his fiduciary duty, but the charter parties themselves were at market rates. There was a claim for dishonest assistance against the 6th and 8th defendant. If I could pick it up at page 2267. Paragraph 68. Well, perhaps I should summarise paragraphs 66 to 68. Novership claimed an account of the dishonest assistant's profits from these charters. The judge then asked the question, where in paragraph 67, where a person is not himself a fiduciary, he may become mixed up in a breach by another of a fiduciary duty. He may be liable in one of two ways: as a knowing recipient of trust property or its traceable proceeds, or as a dishonest accessory to the fiduciary's breach of breach of duty. The former is now known by the shorthand knowing receipt, and the second by the shorthand dishonest assistance. Although for the purposes of legal analysis, it's convenient to distinguish between the two types of secondary liability, a person may be liable under both heads, depending on the facts. Mr. Berry correctly points out that neither a knowing recipient or a dishonest assistant has ever promised either expressly or inferentially to subordinate his own interests to those of the beneficiary. Neither is a fiduciary. In some areas of law, this does lead to a different legal treatment of a dishonest assistant on the one hand and a fiduciary on the other. This is now settled at the highest level in the case of limitation of actions, where a trustee is not entitled to raise a defence of limitation against a beneficiary alleging a fraudulent breach of trust or seeking to recover trust property. A knowing recipient or a dishonest assistant is entitled to rely on the Limitation Act 1980. This is the result of the decision of the Supreme Court in Williams. So there's one area where the analysis of the dishonest assistant's liability is a common law analysis, not an equitable analysis. If I could then move on to paragraph 75. The court considers the numerous cases which refer to a dishonest assistant as being described as being liable as a constructive trustee in equity, and accountable in equity as a constructive trustee. And it asks the question at paragraph 75. It is true that the phrase accountable in equity does not expressly answer the question accountable for what, but if the limit of a dishonest assistant's liability is a liability to make good losses suffered by the beneficiary, it is an odd phrase to use. We agree with Snell that subject to one qualification to which we will come, both a liability to make good loss and a liability to account for profits follow from the premise that the defendant is held liable to account as if he were a trustee to the claimant. My learned friend would no doubt pray that paragraph in aid. And then there's then a consideration of, they say, in our judgment, this position is supported both by policy and authority. There's a reference to the famous case of consul development as to policy. Later on, we now have finally a binding, a clear explanation as to the result of the order that was made in Cook and Deeks and why the order was made against the company in Cook and Deeks, which is nice. Lord, paragraph 84, on page 2272, there's one further point to be made. As Lord Nichols explained in Attorney General and Blake, in proceedings for equitable wrongs in Court of Chancery, the court had a discretion to order an account of profits, even in cases which did not involve fiduciaries. Similarly, Lady Justice Arden pointed out in Murad that it has long been the law that equitable remedies for the wrongful conduct of a fiduciary differ from those available at common law. Equity recognises that there are legal wrongs for which damages are not the appropriate remedy. Whereas here the equitable wrong is itself linked with a breach of fiduciary duty, we see no reason why a court of equity should not be able to order the wrongdoer to disgorge his profits insofar as they are derived from the wrongdoing. Well, stopping there, two things. Your Lordship will see there's a reference to Attorney General and Blake. Attorney General and Blake is the case, the well-known case, where the court said that in certain circumstances it's appropriate to grant, as a remedy for breach of contract, which would be a common law claim, the equitable remedy of an account of profits. And in my submission, it's illuminating that the court takes Attorney General Blake as being relevant to this situation. It comes back to that case later on. Then in paragraph, if I could ask you to go to paragraph 94 on page 2275, causation, could I ask your lordships, please, to read paragraphs 94 to 96 to yourselves?
Yes.
So the court, having established that there's a major difference between a dishonest assistant and a fiduciary, because a fiduciary is just automatically liable for profits that he makes, but that's not true of a stranger. So some causation requirement is required. And as we'll see, it's a common law causation requirement. But if I could go on to page 2277 at paragraph 104, this is important. It is important to appreciate the special position in which a fiduciary finds himself. The essence of the relationship between a fiduciary and beneficiary is that the latter has placed his trust in the former. The core duty of the fiduciary is single-minded loyalty to the beneficiary. Thus, the breach of duty does not consist in the making of a profit, but in the keeping of it for himself. But I do pray that in aid. It's relevant to the earlier analysis. That is not a breach of a personal obligation. It is an abuse of the trust and confidence placed in him by his principal, who put him in a position to make the profit because he trusted him not to serve his own interests. Equity's response to the breach of this trust is not to give redress for the breach in the form of equitable compensation, but to enforce the duty. And there's a reference to one of Lord Millett's famous articles. It is this attitude of equity which explains why a true trustee cannot raise a limitation offence against his beneficiary. And of course, we know that the dishonest assistant can. And then over the page, we agree, in paragraph 105, we agree with Mr. Berry that in the case of one who is not a fiduciary, this approach is inappropriate. For the dishonest assistant has no pre-existing duty whose scope can be determined and enforced. It seems to us, therefore, that the scope of the wrongdoer's liability must be determined by reference to some other principle. In the case of a claim against a fiduciary for equitable compensation, as opposed to an account of profits, in respect of a breach of duty, a court of equity will apply a but-for test of causation, thus precluding recovery for loss that would have occurred even if the breach of duty had not taken place, although the common law rules of causation and remoteness do not apply in such a case. Target holdings. And there's then a citation from Lord Brown-Wilkinson's judgment. And then, Lord, then the point is made in paragraph 106 that although the decision in Target was treated as a case of breach of fiduciary duty, it was in fact a case of misapplication of trust property by a fiduciary, and in that respect is to some extent controversial. And then there's a reference to another article. A fiduciary duty is one that springs from the trust and confidence reposed in the fiduciary. Its key component is single-minded loyalty, but not all duties owed by fiduciaries are fiduciary duties. Thus, for example, the duty imposed by equity on a fiduciary to use proper skill and care in the discharge of his duty, although arising in equity, is not a fiduciary duty. That's Bristol and West. And then there's a citation from Lord Justice Millett's judgment. Halfway down, he says, equitable compensation for breach of the duty and skill and care resembles common law damages in that it's awarded by way of compensation to the plaintiff for his loss. There is no reason in principle why the common law rules of causation, remoteness of damage, and measure of damage should not be applied by analogy in such a case. It should not be confused with equitable compensation for breach of fiduciary duty, which may be awarded in lieu of rescission or specific performance. And then finally, paragraph 107. In our case, Mr. Nikitin was not a fiduciary, either as regards Novaship or the ship-owning companies. He's not sued for breach of fiduciary duty. He is sued because he's committed an equitable wrong. Where a claim based on equitable wrongdoing is made against one who is not a fiduciary, we consider that, as in the case of a fiduciary sued for breach of an equitable but non-fiduciary obligation, there is no reason why the common law rules on causation, remoteness and measure of damage should not be applied by analogy. We recognise that these rules do not apply to the case of a fiduciary sued for breach of fiduciary duty, but that is because the two cases are different. Lady Justice Arden made this clear in the Murad case, and then there's a reference to Satnam. And then it explains the difference in paragraph 108. The common law does not usually apply a simple but-for test of causation. The common law distinguishes between a breach which is the effective cause of a loss and one which is merely the occasion for the loss. How to distinguish between the two is a question of the application of common sense. There's a reference to Galoo. Common sense, as we have seen, also plays its part in determining the extent of equitable compensation. So, and then finally, my Lord, paragraph 118, which is on page 2280. Mr. Brindle relied on the inflexible rule of equity that where a fiduciary has made an unauthorised profit within the scope of his duty, he's bound to account for it to his principal. We do not wish to cast any doubt on that well-established principle, but at the risk of tedium, we repeat that Mr. Nikitin was not a fiduciary and is not sued for any breach of fiduciary duty. We consider that where a claim for an account of profits is made against one who is not a fiduciary and does not owe fiduciary duties, then, as Lord Nichol said in the Blake case, the court has a discretion to grant or withhold the remedy. We therefore agree with Miss Justice Toulson in the decision in the Fifes case that the ordering of an account in a non-fiduciary case is not automatic. One ground on which the court may withhold the remedy is that an account of profits would be disproportionate in relation to the particular form and extent of wrongdoing, and then the case continues. So, Lord, drawing the threads together, the dishonest assistant is liable to account, or can be made liable to his account for his profits, a bit like a fiduciary. But his liability is much more like a common law liability than it is an equitable one. Causation and remoteness, they're the effective cause test, not but for. Reasonable foreseeability, not novus actus interveniens. And the grant is a matter of discretion, it's not a matter of principle. The reasoning in Blake was applied. Of course, Blake was a case of applying the remedy of an account to breach a common law claim for breach of contract. So, in all these instances, the court is actually fashioning a remedy which is far closer to common law cause of action than it is to an equitable one. And the critical point, well, it's obvious, but I would say it's the elephant in the room, the dishonest assistant is only liable for his own profits. He's not to be made liable for the fiduciary's profits. That would be contrary to the essence of the essential decision made in Novaship. It's interesting to note that that demonstrates that the dishonest assistant's liability is not always coextensive with the fiduciary's. Although Royal Brunei tells us that the dishonest assistant has a secondary, or for want of a better word, accessory liability, it does not follow that the measure of the dishonest assistant's liability should always be the same as the fiduciary's. It will often be the same, but there is no absolute rule of coextensiveness in my submission. In any event, if we could now look at the judgment, paragraph 296.
So we don't need Novaship anymore.
We don't need Novaship.
Before you leave Novaship, let's not go back to it itself. As I was listening to you, the penny dropped that I had a case about Novaship in the Court of Appeal a year or so ago, which I think has gone to the Supreme Court, which is about the accessory liability for an account of profits. The liability for an account of profits of an accessory in an intellectual property case.
In an
intellectual property case, which is another area in which accounts of profits are come up. I doubt it's relevant. You ought to know. It does bear on some of what you were talking about. And since it's gone to the Supreme Court, I don't know what they're going to do with it. So you might just care to spend 5 minutes seeing if there's anything relevant in there. If there isn't, fine, that's good. But
Lord, thank you. You don't recall the name of the case?
sorry, yes, lifestyle equities.
Lifestyle equities, thank you.
I knew I'd seen membership before, and I couldn't remember why. Thank you.
Judgment. Page 198 of the core bundle, paragraph 296. The judge here explains why he doesn't find his analysis satisfactory.
Entirely satisfactory, or wholly intuitive.
I didn't mean to be tendentious.
No.
And he gives 4 reasons for thinking it might not be satisfactory. First of all, he says that the success of the argument elides many of the distinctions between claims for an account of profits and claims for equitable compensation. Secondly, he says in substance, HB2's complaint here is that Mr. Ruhan abused his position as a fiduciary to make a profit, which HB2 would not have made for itself, and that Mr. Stevens dishonestly assisted him in that. It might be said that as a matter of substance, that is a claim for an account, and it should carry whatever legal consequences follow from that categorisation. Of course, I do say that, my lord. And then 3, in certain factual scenarios, he says, including this one, the argument might be said to come close to rendering the dishonest assistant liable for the profits made by the fiduciary, even though English law has not chosen to render dishonest assistants directly so liable, and also to permit such a claim as of right, notwithstanding the strong discretion which exists in determining whether to order the dishonest assistant to account for their profits, and perhaps without the benefit of the more exacting causation test, which would have applied to such a claim. Now, stopping there, the learned judge says might be said to come close to rendering the dishonest assistant liable for the fiduciary. In my respectful submission, that's an understatement. It does precisely that. On the facts of this case, in substance, Mr. Stevens has been ordered to pay an amount which is equivalent to an account of the profits which Mr. Ruhan received from his breach of fiduciary duty. But, Lord, there's a wider point here. I make this point not just on the facts of this case, but on the facts of all cases in which dishonest assistants assist the fiduciary in making profits. We make the point for your lordship's note, we make the point in paragraph 63 of our skeleton. Lord, the point is actually covered by authority, which we weren't aware of at the time. It's the case of Group 7 against Nazir. It's in Bundle 7, behind tab 49. This was a decision of this court in 2020. Fraudsters had obtained 100 million euros by fraud, and they'd loaned it to LARN, L-A-R-N, a company which was owned by one of the fraudsters. LARN then transferred the money to the client account of a firm of solicitors called Notable. On LARN's instructions, the solicitors made a series of payments out of that account for the benefit of the fraudsters. Those payments totaled about 15 million euros. The trial judge held, that in giving those instructions to the solicitors, LARN, the company, was in breach of a duty that it owed as a constructive trustee of the money. One defendant, a man called Luangeli, was held liable for dishonestly assisting that breach. Now, what's important is the nature of the assistance that he gave. His assistance consisted of making statements to the firm of solicitors, Notable, with a view to persuading Notable to accept LARN as a client, and therefore to accept the 100 million euros that are being paid into its client account. So his assistant essentially was in making it possible for Lahn subsequently to give instructions for the disposal of the €15 million euros. Louangeli appealed against liability as dishonest assistant, and his appeal was dismissed. What that shows is that dishonest assistance of a breach involving Lahn instructing solicitors to make payments out of the client account can be given by assisting Lahn in persuading the solicitors to accept the money into the client account in their first place. In other words, if someone helps create an opportunity which subsequently allows a breach to take place, that is enough to constitute dishonest assistance of the breach that ultimately takes place. Your Lordship sees the reasoning of the court at page 2506, paragraph 110. They say, first, we accept the legal analysis of the respondents. On authority, the matter must be approached in two stages. It must be shown that the conduct in fact assisted the breach of trust, and that the loss directly resulted from the breach of trust. The test at this first stage is that the assistance given must be more than minimal. That's Barden and Societe Generale. The test at the second stage is that the loss in fact resulted from the breach of trust. So what's required is more than minimal assistance. 2, it is made clear by target and by AIB that there's no warrant for introducing common law concepts into this area in the manner proposed by the appellants. What must be shown is that the conduct assisted the breach of trust, and but for the breach of trust, the loss would not have occurred. The statements in Novaship arose in the different context of a claim for an account of profits and don't assist the appellants in the present circumstances. And then they say, even if, contrary to our view, there was some substance in the appellant's advocacy of some stricter test of causation, so that there needed to be a direct link between the assistance and the loss, as opposed to the breach of trust and the loss, it wouldn't avail them on the facts of this case. Now, what's significant about this case is first of all, the court reminds us that the assistance only needs to be more than minimal. But secondly, it shows that the assistance doesn't have to be direct. The assistance given in that case was not in relation to the payment out, it was in relation to the payment in the first place. If you assist someone in creating an opportunity for themselves, then to commit a breach of trust, that your assistance in the creation of the opportunity is itself assistance in the breach of trust. Now, the reason why I'm rather ponderously saying these things is because it has a direct bearing on the facts of all cases where a dishonest assistant assists a fiduciary in making a profit. By allowing the fiduciary to make a profit, the dishonest assistant gives the fiduciary an opportunity to dissipate that profit. I mean, the whole point of making a profit for yourself is that you enjoy it. So clearly, given the low threshold for assistance established by the authorities, wherever a dishonest assistant provides assistance to the creation of a profit, the law will take that dishonest assistance as having also assisted the ultimate dissipation of the profit. So, if I assist you to make a profit, thereby creating an opportunity for you to retain or dispose of the profit, and you do in fact dispose of the profit, and if the disposal itself constitutes a breach of constructive trust, which it always will, then even though I did nothing to help you in disposing of the profit, if all I did related to the original making, even if all I did was related to the original making of the profit, I am still liable for assisting the ultimate breach of trust or fiduciary duty in disposing of the profit. Now, what does that mean on the facts in practice? Applying that principle to the judge's analysis, in every case where a party simply assists a fiduciary in making an unauthorised profit, and he assists nothing else, he will also be treated as assisting the fiduciary's disposal of those profits. And as the fiduciary always holds those profits on constructive trust for the principal, a disposal of those profits can always be seen as a breach of the custodial duty of trust, the custodial duty, full stop. So if the law treats the custodial breach as not only separate, but independent and distinct from the fiduciary's original breach in making the profit for himself, the result is that where the profits have gone, the dishonest assistant whose sole job was to help in the making of the profit will always be liable for the profit ultimately made. My lords, that is the exact opposite of what was decided by this court in Novoship. It decided that the dishonest assistant is not liable for the fiduciary's profit, it is only liable for his own profits. And lords, that's not the only inconsistency with Novoship. First of all, as the judge himself recognised in paragraph 296 of his judgment, the effect of his decision is that HB2 is entitled to recover the profits, or any claimant is entitled to recover the profits from the dishonest assistant as of right, rather than as a matter of discretion. And what's more, HB2 can do so without having to show any causal connection between the acts of dishonest assistance and the dissipation of the profits, let alone having to satisfy the real or effective cause test, which is imposed by Novoship. That's why I submitted at the beginning of my submissions this morning that the result in this case is amazing. In my respectful submission, something has clearly gone wrong. The outcome is inconsistent not only with the result, but also the reasoning of this court in Novoship. And it can't be explained away on the basis that the remedy in the present case takes the form of an award of equitable compensation rather than an account of profits as in Novoship. The result applies across the board to all dishonest assistants who have assisted in the making of an unauthorised profit. And I know I'm repeating myself, but it really shouldn't be forgotten that however one dresses up the analysis, this is in substance a secret profits case. What Mr. Stevens was doing was assisting Mr. Ruhan to make an unauthorised profit for himself. And that was all that he was doing. It is artificial in my submission to treat the fiduciary's making of the profit for himself as separate from his enjoyment of that profit. And it is artificial to suggest that HB2 suffered a genuine loss as a result of the assistance. The appropriate remedy in this case was an account of profits as against Mr. Ruhan and also as against Mr. Stevens.
And we need to find a moment to break.
That may be a convenient moment.
And just help me, you've got a little bit more to say about this, have you? And then you've got compound interest to deal with.
Yes.
But I assume we're still on schedule.
We are on schedule. I was hoping to finish by 12. It may be 12:30 or 1 tomorrow.
Yes, I see. Fine. Well, we'll start again at 10:30 in the morning. Just give me a moment.
May I just, before your lordship tries, may I hand up the authority on equitable set-off? Your lordship, I'm not suggesting your lordship should read it overnight, but I perhaps will be briefly referring to it tomorrow morning.
Much.
10:30 in the morning.
All right.